Home inspections are one of the most common conditions we see in real estate transactions. What makes them interesting is that the findings of a home inspection can lead to a couple of different changes in the agreement of purchase and sale. It's a unique clause in that it creates further negotiations more often than any other common condition. I've seen this play out on both sides as a realtor drafting these clauses and dealing with the negotiations, and now as a lawyer enforcing them up until closing. So if you're buying a property with a home inspection condition, this video is for you, because the decision you make after that inspection report comes back can make a big difference in your closing. My name is Soccio-Marandola. I'm a lawyer here in Toronto, and I help people like you close real estate deals every single day. If you enjoy this type of content, make sure you subscribe and join our community. And if you have a closing coming up, we've built the most transparent legal fee calculator online. It gives you a full breakdown of every dollar you'll spend and even calculates closing costs like land transfer tax and title insurance. That's linked in the description down below. So what is a home inspection condition? Let's start with the basics. A home inspection condition is a clause in your agreement of purchase and sale that gives you, as the buyer, the right to have the property professionally inspected before the deal goes firm. Now, the condition is typically drafted so that if the results of that inspection are not satisfactory to you, in your sole and absolute discretion, you have the right to walk away from the deal entirely. It's common on freehold properties. We do see it occasionally on condos, but less so. And of course, the scope of what can actually be inspected is different. Now, we're going to turn and actually look at what a standard clause for a home inspection actually looks like in an agreement of purchase and sale. Here's an example of a standard home inspection condition. As you can see here, this offer is conditional upon the inspection of the subject property by a home inspector at the buyer's expense and the obtaining of a report satisfactory to the buyer in the buyer's sole and absolute discretion. Unless the buyer gives notice in writing, delivered to the seller personally or in accordance with any other provisions for the delivery of this notice in the agreement of purchase and sale or any schedule thereto, not later than 11:59 p.m. on April 30th, 2026, that this condition is fulfilled, this offer shall be null and void, and the deposit shall be returned to the buyer in full without deduction. The seller agrees to cooperate in providing access to the property for the purpose of this inspection, and this condition is included for the benefit of the buyer and may be waived at the buyer's sole option by notice in writing to the seller, as aforesaid, within the time period stated herein. So what does this all mean? To simply put it, the offer is conditional upon the inspection of the property. So buyers allowed to get a professional home inspector in the property to actually go through and look through everything that they can and properly inspect. And basically, they're going to provide a report, and that report has to be satisfactory to the buyer in their sole and absolute discretion. Then we have the provision for delivery. So written notice has to be given to the seller from the buyer that says, hey, we're either fulfilling this condition by this date, or if not, then the deal becomes null and void and the deposit is returned. There's a couple extra clauses in there, a couple extra lines. It says the seller agrees to cooperate in providing access. That's to make sure that, they can't just deny you the right to go in, even with the inclusion of this clause. And then of course, because it's for the buyer's benefit, they have an option to waive it if they so choose. So that's what most home inspection conditions look like. Comes from a standard template, often drafted by realtors. Most of them will look almost identical to that. So now what happens after that inspection report comes back? So the inspection report is done, the report comes back, now what? In a lot of cases, the answer is simple. There are no issues, or the issues are minor enough that the buyer is comfortable moving forward, then the condition simply gets fulfilled and the deal continues. Sometimes those minor things were already known and maybe already built into the price that was negotiated. In that situation, no further negotiation is needed. But then there are some cases where something comes back in that report that genuinely concerns the buyer. Maybe it's a roof that needs replacing, a cracked foundation, an aging HVAC system, something material. Now this is where it gets interesting, because at this point the buyer has a couple of options, and the one that you choose matters more than most people realize. So option one, the first option is a price adjustment. The buyer can agree to fulfill that inspection condition, the deal goes firm, but the parties also agree to amend the purchase price to reflect the new information. Now I want to be clear about something here. This is not automatic. Just because the inspection found something doesn't mean the seller has to drop the price. It's still a negotiation. There's no guarantee that it happens. The timing of the condition matters too. How much runway is left before the condition deadline? How motivated is the seller? What's the market doing? All of that plays into whether the conversation even gets off the ground. But when it does work, when both sides agree on a number, the buyer walks away with the difference in their pocket, and from there they decide what gets fixed, when it gets fixed, and who does the work and to what standard. That's a lot of control. And that's why when possible, this is always my first recommendation. A price reduction puts the buyer in the driver's seat. Now, the second option is a repair clause. So instead of adjusting the price, the buyer agrees to fulfill the condition on the basis that the seller will complete specific repairs before closing. But I'm going to warn you, these types of clauses are a lot harder to get right than it looks. And that's because there are several things that need to be nailed down in the contract. And even when they're drafted well, there's always a level of subjectivity. So first, let's talk about some of the issues that I do see come up with repair clauses. Now, the first is defining what needs to be repaired. Now, this sounds obvious, but it's easy to get vague, right? Fix the roof is not a contract obligation. You need to be specific. Which section, what's the scope of that work, what materials. The second is the level of repair, right? Is this a patch job? Is it a full replacement? There's a big difference between a seller applying a temporary fix and a seller doing a proper repair that addresses the underlying problem. Third, and this one gets overlooked, is the workmanship and quality, right? Who does the work? Does it need to be a licensed contractor? Does it need to comply with applicable codes? A seller can technically complete a repair in a way that meets the bare minimum of the clause and still leaves you with a poor result. Then there's the question of evidence. How do you know that the work was done? Do you get copies of invoices, permits, a warranty from the contractor? And that leads to the next issue, inspection of that completed work. Does the buyer have the right to inspect the repair before closing? If so, when and what happens if the buyer isn't satisfied? Warranty is another one. If something goes wrong 6 months later after closing, does the buyer have any recourse under that clause? Typically not, unless it was specifically drafted in. And finally, enforcement. What happens if the work just isn't done on closing day? So I'm going to show you a couple of examples of these clauses. I want to be clear that these are just examples of clauses I've seen in agreements of purchase and sale, and I'm going to give you a bad example and a good one. Every situation is different though. These clauses always need to be custom drafted for the specific circumstance. And of course, the more specific you can be, the better. So this is from an agreement that came through my office a couple years ago. And it simply said, the seller agrees and warrants to complete the roof repairs before closing. In case of any incomplete work, the seller agrees to pay the cost of that job on the completion day through the lawyer. Now, as you can see here, this is extremely vague, right? What are the roof repairs? They haven't been described here. So, I mean, I understand that there's an assumption that both the buyer and seller know what's talking about, but that easily comes into dispute, right? It's going to be a he said, she said situation, right? And then even this supposed remedy portion, the second sentence, in case of any agreed or any incomplete work, the seller agrees to pay the cost of that job. Now, who's deciding on this incomplete work, right? This is a problem that plagues virtually any clause you're going to write up because either party cannot be the judge of a situation. We ended up redrafting it, but this is just, again, an example of the stuff that does get put in. And obviously it shows that problems can arise. So here we have a much better example. And right off the bat, you can see the difference in the length, right? We're talking about the same kind of issue, but obviously, this is taking up almost a page rather than 2 sentences. So in this one, we've got a whole different set of sections that kind of cover everything that should be covered in a repair clause. So we've got the scope of work, right? The seller shall, at the seller's sole expense, repair the damaged roof flashing and lifted shingles on the north-facing slope of the property as identified in the home inspection report dated March 20th, 2026. Otherwise known as the inspection report. The scope of the repair is limited to the deficiencies described in the inspection report and shall not be interpreted more broadly. So what I love about this clause is it actually went and referenced another document. And you can then attach that as a document to the agreement of purchase and sale, right? Then we have the inspection report and we have the exact language and deficiencies. That's a great way to handle these kind of clauses, again, if you have to go this route. Now we talk about standard of work and contractor. All work shall be completed by a licensed roofing contractor in a good and workmanlike manner in accordance with applicable building codes and manufacturer specifications. The seller shall provide the buyer with the name and license number of the contractor retained to perform the work no later than 10 business days after the acceptance of this agreement. Now again, it's good. It's setting out different obligations, being that they have to provide the name and license number of the contractor. Now, we're still dealing with words like good and workmanlike manner. Those are always going to have a level of subjectivity. And that's what I mean. Even well-drafted clauses are going to have some issues with them. So then we have deadline and evidence of completion. All work shall be completed no later than 5 business days prior to the completion date. The seller shall deliver to the buyer's solicitor written confirmation of completion including the contractor's invoice and written warranty of no less than 1 year on both labor and materials. So obviously this puts another obligation, right? It needs to have warranty with the specific repair. So these are always going to change based on what work is going to be, or what work is being completed, right? Sometimes specific work won't naturally come with such warranties, so obviously it will be dependent. Then we have buyer's right to inspect. The buyer shall have the right to inspect the completed work no later than 2 business days prior to closing. If the buyer reasonably determines that the work has not been completed to the standards set herein, the buyer shall provide written notice to the seller within 1 business day of that inspection. So even in this clause, again, we have a level of subjectivity. If the buyer reasonably determines, right, then we're defining reasonably. So that's why even these well-written ones are still going to, or still can lead to disputes. Finally, we have a remedy portion. So if the work has not been completed to the required standard, or if satisfactory evidence of completion has not been provided by the deadline above, the buyer may, at the buyer's sole option, either terminate this agreement and receive a full refund of the deposit, or B, proceed to close, in which case the buyer shall have the right to arrange for the repair work to be completed by a licensed contractor of the buyer's choosing, and the seller shall be liable for all reasonable costs incurred in the buyer doing so. The seller shall reimburse the buyer for such costs within 10 days of receiving written demand, accompanied by the contractor's invoice. If the seller fails to reimburse within that period, the buyer shall be entitled to pursue such costs as a debt owing. So again, this is good. It's very specific, right? There's an option to terminate, which is really strong, which is usually a very good incentive to get things done. And then B, you've got essentially a clause that says the buyer can go in and do those repairs and then claim that back. Now, of course, if the seller just decides not to pay, then you're bringing an action to enforce this contract based on a breach of contract. So, at any point, regardless of whatever kind of contract you have, the best written one in the world, if you have to enforce it, you still have to go through a court process, which no matter what is never fun. So that was my bad and good example. And I can't reiterate this enough, that these clauses are not meant to be a sample. Even that good one is not just meant to be a template. It really matters about the specific situation, the details of the repair, and the details of the situation. So to bring this all together, a home inspection condition gives you options. When the inspection comes back with something concerning, you do have the ability to negotiate. You can pursue a price reduction, or you can push for a repair obligation. Both are legitimate paths, but they're not equal. A price reduction keeps control in your hands. A repair clause puts you in a position where you're depending on the seller to perform, and then depending on the contract to protect you, and of course, potentially needing to enforce that contract. I know these decisions feel high stakes, but that's because they are. But understanding the difference between these options before you're sitting at the table is exactly the kind of thing that leads to a better closing. If you're enjoying these types of behind-the-scenes real estate law videos, make sure you subscribe to the channel. I post a new video every week. And if you're a realtor, I also send a weekly update about different legal situations that come up in our closings. That's our Realtor newsletter, and you can subscribe to it with the link down in the description. Thanks for watching.